people sort of bury their heads in the sand when there's an initial diagnosis of, let's say, dementia or Alzheimer's or any other type of cognitive impairment. And to answer your question, when somebody hasn't done their planning in advance, it could cause a lot of hiccups.
So let's start there and talk about capacity as well, because cognitive impairment now demonstrates a lack of capacity. You're no longer of that sound mind and body to be making certain legal decisions.
Well, it's interesting, and I think that's a good, these are all topics that we've touched upon in the past, but we've, like you said, have run out of time, and they're common questions. So legal capacity, as you know, because you're an attorney, is different than what a doctor might consider to be capacity, right? So legal capacity is understanding the what we would say the gravamen or the details or the substance of a contract, right? It's contractual capacity. So when somebody comes into our office, especially with the onset of dementia, they may have a diagnosis from a physician that they now have dementia.
Okay.
And whatever course of treatment the physician prescribes, but that doesn't mean that they don't have legal capacity.
Okay.
Right? So legal capacity, again, if I were to take a contract for the sale of your house and put that contract in front of you and say, I would expect you to ask questions like, well, how much are we selling the house for? Where am I going after I sell the house? When is the closing date? How long do I have before we have to sell the house, right? These are all questions that would go to the substance of the contract. And if you understand the contract, then you have legal capacity. So let's take that and put it into the world of elder law and estate planning, right? If you come into my office, and again, somebody that's got the onset of a cognitive impairment, and I want to draft a power of attorney for you because you have not done your planning in advance, I am going to ask you questions like, well, if you can't handle your finances, who do you want to handle your finances? Who would be the right person to help you handle your finances? What type of assets do you have? Do you own a house? Do you have bank accounts? Now, I'm not asking for you to give me account numbers.
Right.
I'm not asking for you to even give me necessarily the exact values of your accounts.
Okay.
I just want to know in general terms that you have an understanding of your assets. You can appreciate your family members, if you would, and that likely will get us over the legal hurdle of capacity.
So just by your ability to have a lucid conversation, a general awareness of matters such as, what you have, even without the specifics, but really a lucid conversation touching upon personal finances, personal holdings, would get over that threshold that you have legal capacity.
You need a little bit more for a power of attorney. A power of attorney is contractual capacity.
Okay. You have to know, you have to be able to know exactly what that contract
you've got to understand the gravamen of the power of attorney. A last will and testament now, however, is one lucid moment.
Really?
Right. So the capacity needed to sign a last will and testament is a lot lower.
So there's gradients of capacity.
Definitely.
So getting a diagnosis of a cognitive impairment for a doctor is what you're saying basically is just having that medical certification is not enough to show diminished capacity or lack of capacity.
Not at the initial stages.
Okay, so in the beginning. So this is important too because
it's very important. But I'm sorry to cut you off, but because a lot of people think that that the ship has left the dock.
Correct.
From an estate planning perspective.
Correct. And even their loved ones who are ready to step in, they might prematurely step in. So this is really interesting. And people might think as well that, okay, the doctor's just diagnosed X condition. This is it for me. So what you're offering is, another perspective that, like you said, we have to really take this on a case-by-case situation.
That's right.
And really evaluate the person of whom we're planning for.
That's right. That's right.
Is it safer to err on the side that capacity is lacking, or do you find it's important to really look at the situation for
Well,
what it is?
I think the answer, I think those are two questions, right? As an attorney, we want to do our due diligence. We don't want to cross that line where we determine that somebody may have capacity and then they don't, and then we end up in all different kinds of problems after that. But we want to do the due diligence. We want to ask the right questions, and we want to give people the opportunity to show us that they have capacity.
Okay.
But make no mistake, there have been plenty of situations, and we see this often as elder law attorneys. People come into the office, we go through our line of questioning, and we can't get that comfort level.
Okay.
Then we have to do a guardianship.
Okay. So that, I think, is an important distinction. Guardianship, if you're just joining us, Sal Di Costanzo, elder law attorney with Maker, Fragale, and Di Costanzo, offices in northern Westchester and southern Westchester. He is our go-to legal expert. Even myself in the funeral home send many families his way because a trusted, knowledgeable elder law attorney. And there are such specific issues that arise with elder law that can't really just be left to a general practitioner. You need an expert on this. And Sal lectures, authors, really has worked extensively in this area. And he just touched on the subject of guardianship. So we've been talking about capacity, when capacity is considered diminished, when it's time to bring someone else in. But I want you to distinguish now the difference of guardianship and power of attorney, because it's a very important legal distinction. There are two totally different situations that arise. So help our listeners and viewers with that, please.
So a power of attorney gives somebody the ability to manage your financial assets and do other things, right? It's important to note, and we've talked about this in the past, you don't want to just pull a power of attorney off of the internet. You don't want to fill out just a boilerplate form.
Correct.
When you come to the office of an elder law attorney, we modify the form of a power of attorney to put a lot of powers in there that you probably wouldn't even think about, and you might not even use. So, for instance, the power to move your assets out of your name, that's not in the standard form of a power of attorney, right? And people say, well, Sal, why would I want to do that? Why would I want to have this power to give away my assets? I don't want to make gifts. Well, as you know, as an elder law attorney, we do a lot of Medicaid planning.
Correct.
And one of the fundamental tenets of being Medicaid eligible is that you cannot have any assets in your name, or a very limited amount of assets in your name. Mm-hmm. So we need to have that power to move those assets around, right?
Absolutely. And if those assets aren't moved within the requisite times, it just starts a whole slew.
It's a mushroom effect.
Yeah, exactly. So having the ability to have someone move those assets is key. And even, again, if you think there's a possibility down the road, there's a lot of foreshadowing involved here.
It's all advanced planning.
It's all advanced planning, and you have to look at the what-if scenario. Mm-hmm. You could be 70, healthy, 70's young, 70's active, but you have to now, at 70, look at 80.
That's right.
And think what 80 might look like.
That's right.
And you have to also, you can't just look at family genetic history. You have to look at the possibility of a what if. What if there's an accident? What if there's, and it's a horrible, mindset, but you have to be in that mindset.
Well, it's interesting that you say that, because a lot of people come to our office and we draft documents, and they come in and they say, wow, why so many pages, right? And the reason being is because we try to think on a prospective basis.
Yeah.
If I draft your last will and testament, we're planning for generations.
Yes.
We're planning for incapacity, which may never happen. But what happens if, God forbid, you pass away at a young age and you've got minor children? What happens if you become disabled, or your child becomes disabled? These are all things that we draft, in advanced planning. But people sometimes don't realize that takes a lot of pages to do that. But I want to focus again on this onset of an incapacity, and also a very common theme that we see often, Jen, is people have their capacity, but they may not have the physical ability to sign their documents.
So let's talk about that situation. Let's say
So
someone's
one of
been
my
in
very
an
first
accident.
cases, many years ago, it seems like now, I was working with an ALS patient,
Okay.
right? And I went to his house, and which I still do things like that. I might be one of the dinosaurs out
The
there.
attorney
but I
that makes house calls.
I
You
still,
heard it
not
here.
all the time. We don't want to. Not all the time.
Well, you just said it yourself. You opened the floodgates.
But I am not afraid to help somebody in need. So I will go see people. But I went to his house, and as we all know, sometimes most ALS patients, he could talk, he could communicate.
Right.
He was blinking his eyes, but he couldn't lift his hands.
So he had cognitive ability. He demonstrated,
Mm-hmm.
cognitive presence, if you will.
Right.
But there was a physical impairment.
So the law, the power of attorney law was recently changed to accommodate this type of situation.
Oh, okay.
If somebody can direct, so we call it a principal, right? So if I'm going to do your power of attorney, you're the principal. If you could direct somebody to sign your power of attorney on your behalf, that person can sign your power of attorney.
Now, do they sign it in their name or yours?
No, in their name.
In theirs.
Well,
And
I'm sorry. They sign your name.
they
to
sign
the-
your
to
name.
the
Now,
power of
correct. Is
attorney.
there some type of addendum
That's right.
that's
Yeah.
included to
Yeah.
demonstrate
Well,
that?
we sort of doctor up the power of attorney, but it's not. A lot of people. I want people to know this. I want our audience to know that even if you are physically incapable of signing, it could be a stroke victim, right? It could be Parkinson's. It could be. There's so many different things that could cause you or prohibit you or inhibit you from signing. A seasoned elder law attorney knows that if you can direct somebody else to sign on your behalf, we can still get that power of attorney done. There are a lot of people that don't know this, and then you end up in a guardianship proceeding.
Okay, so now break that down. The guardianship, we've heard a lot about it in recent months in the news and the media.
Yeah.
I always talk to you about the Britney Spears
Unfortunately,
scenario.
what you're reading and hearing in the media is not all that accurate. I'm not saying it's inaccurate, but you've got to
Media not being accurate? Oh, that's a shocker.
you've got to vet it out.
So vet it for us. A guardianship.
So a guardianship is when somebody has not taken the opportunity to do their planning in advance. It could be for healthcare purposes, which is a healthcare proxy, or it could be with a power of attorney, which is for financial purposes. And there is a need to make healthcare decisions. There's a need to make financial decisions. If we don't have a valid power of attorney or a valid healthcare proxy, the next course of action is to go to court, present this person and their fact pattern to the court, asking the judge to have that person to be determined to have what we call functional limitations. Because a guardianship doesn't mean necessarily that you're incapacitated. You could have a guardianship over a parent because of elder abuse. You could have a child that's pilfering the parent's assets, and the parents just don't realize it.
So who is the person then who commences the action?
It could be any interested party. It could be anybody.
So define interest. Could you be a resident of a nursing facility and the administrator or social worker in the facility?
Happens all the time.
So but again, there's a standing. Standing is based on interest. Now, it's difficult to come out of a guardianship, correct?
Most likely.
So now let's say you have this scenario where the nursing home, the healthcare social worker is witnessing this, and the child is trying to prevent it from happening. I mean, I can imagine sometimes guardianships open the door to contentious proceedings, correct?
Yeah, so if a nursing home is commencing a guardianship proceeding, it's generally because they're not getting paid.
Okay.
But that's not always the case, but often that is the case. Sometimes a nursing home or an assisted living facility is commencing a guardianship proceeding just because the person doesn't have a family member or had a family member that no longer is in the picture, and decisions need to be made. But sometimes it's because of non-payment.
Okay.
Other times, we do a lot of guardianships in my office for planning purposes. So somebody might go into a nursing home and they have some assets. But there's things that I can do as an elder law attorney where I can implement certain planning techniques. Maybe I want to set up a trust.
But in doing that, why would guardianship be necessary?
Because I don't have that person has no capacity.
Okay.
And
So
I
we're
don't
already
have
at that
I don't
point.
have a power of attorney
Okay.
to be able to do these things that I would want to do.
Okay.
So I might go into court and say, Judge, here are the facts. This person went to the nursing home, this, and I ask for the appointment of a guardian who has the power to then do the things that they would have done if they had a power of attorney.
Okay.
So guardianships are for planning purposes, and then you've got guardianships where there is something like elder abuse, or a child is like I said before, pilfering the assets or misappropriating the assets. Usually happens with these close confidential relationships where, like, daughter is living with mom and has access to the bank account, and the other siblings are someplace out of state, let's say, or wherever the case is, and they're just trusting that the daughter's handling everything appropriately, and then they find out that she's not. So you commence a guardianship proceeding. So that way we can take control of the assets and the affairs of the parents. Likely because one of the reasons, the kids are going to fight. The court's going to favor the appointment of a child as guardian, but where you've got an adversarial relationship.
Yeah, when you have multiple children, and will the court tend to favor the one in closest geographic proximity, or sometimes no?
Not if there is, or if there are allegations of wrongdoing.
Okay. I think what's important, and I hope what people take away, is having the proper person in place. So if you have somebody who is single, not married, no children, no siblings, or okay, maybe one or two siblings, but that's the scenario where, if God forbid something happens, where there's an accident, a stroke, a sudden onset of illness, or anything that could render that functional limitation, who is the person that would step in? So that's why it's so important to be thinking and mindful of planning, and who is your person. And the person that you designate could be anyone. It doesn't have to be a blood relative. It could be a trusted friend, advisor. But it's so important to have that person lined up for that what-if scenario.
That's right.
Because you never know the things that could happen. But if you haven't designated someone to act on your behalf, if you don't have that fiduciary upon whom these responsibilities can fall, this opens the door for all of the scenarios that you just posed here today.
Absolutely. Single individuals are, some of our, our I'm not going to say our biggest clients, but we work a lot with single individuals. Especially, people say to me, Sal, at what age should we come to you? And I answer them, say, any age.
Yeah.
Right? But when you really start to see the floodgates open, are like, in the 40s, divorcees with children, that's so important, because often we might want to set up a trust, right? Especially if there are minor children, right? And one thing that it's amazing how many people out there don't have an estate plan.
That was very
It's
true.
just unbelievable.
I'm blown away when I hear it, or especially in cases where there is significant wealth.
But I think there's a misconception that you have to have significant wealth to come in and do an estate.
I agree with that, and the truth is that anybody with any stake in the game,
absolutely,
should have a plan in place.
At least just a power of attorney in a healthcare process.
Even just the basics.
Anybody could have a stroke at any time.
It's very true. And again, we're not here to start your Monday with all these doom and gloom scenarios, but the what ifs are real, and you and I have both seen them.
Very real.
So we come today saying these are not these far-fetched scenarios. These are calls that you and I get on a daily basis. And the whole goal of the show is to raise awareness to these situations and have you prepared in a better position.
That's right.
I know you're working with a family right now that this is, all come into play. And you have to, it's funny, we always think of the people who are single and unencumbered, no spouse, no children. We tend to think, wow, they're so carefree, like, wow, they're living the life. But those are the ones that really have to think about this. And it's not a negative thing. It's just who is your person, and it's just something to think about. I even say this in funeral planning. There's an agent letter, and I work extensively with families, especially those scenarios where I say, God forbid something happens, who's going to be the one to make the call for me?
That's right.
You know, they say, oh, I just want a simple cremation. Okay, cremation, there's a ton of liability. So someone has to assume responsibility to sign off on that. Who is it going to be? And it's not just you thinking of someone, it's also you communicating with this person to make sure they're on board. And that's an important piece of the puzzle as well.
That's right. I think the key for today is to make sure that people recognize that it's never too late. I think I've written blogs about that with that title. It's never too late. So many people call up and they're like, well, I didn't think I could do it anymore.
Right.
Or, you know, why didn't you bring your mom in when she had the onset of dementia? Well, I thought it was too late.
There's never too little and it's never too late.
That's right.
I think that's important. And on the flip side, if you have plans in place and you have designated people and then life has happened, there's divorce, there's estrangement, you have to go back and look at your plans and make the necessary adjustments.
It's funny you say that because it's one of the biggest issues that we see in our practice. People come into my office, they draft their estate plan, and then they just take it and they put it on the shelf.
Yep.
And I've been doing this for, long enough now where I see the repercussions of it. And no matter what my involvement is, and all of the instructions that I give you, I'm not there on a monthly or annual basis to say, hey, did you take a look at your estate plan? Is there anything that needs to change? And it's a big problem. It's a really big problem. And one of the things that we're thinking about doing in my office is trying to create a system now or a program where people come back in maybe once a year.
Yeah.
To come in and review their documents, and maybe there's nothing to change. Often there won't be anything to change.
Listen, birth, death, marriage, divorce, all these life events kind of change who's in our circle and out of our circle. You can be in a very trusted, close friendship with somebody that you believe at the time is the right person to handle your affairs. And then, again, life happens. You might still be friends with them, but you might no longer think they are the best person to represent you and your wishes. So it might be time for a change of the designee. But it's important to do that administrative housekeeping because life changes. Our circle is ever evolving. People in, people out. Even divorce doesn't automatically, if people are named, designated, power of attorney, left in a will, beneficiary, that doesn't automatically just leave by being divorced.
If you get divorced, that's all canceled out.
But you have to actually change a beneficiary, let's say of a life, or if you have a power of attorney that you've designated as a spouse, you would have to actually change that.
No,
or that's
so
automatic?
New York State has certain laws that once you have a divorce, that's cut out.
But not for a life insurance policy, correct? Or
I'm not sure about that. I think, and I'm not a matrimonial attorney, but I did lecture on this once. But I would have to go back to my notes. I think that it cuts out the beneficiary designation.
Okay.
But that's important.
Well, nonetheless, it does make you stop and think: if you have chosen somebody, who have you chosen?
The real issue, and I know we've got to go, but the real issue is, just to mention this, these are all good tidbits, right?
Right.
People that are going through a divorce, we get a lot of referrals from matrimonial attorneys because until you're divorced, you're still legally married.
Absolutely.
And so many people come to us in the process of being divorced, and we change their documents.
Sal, where can people read the blogs that you've written and learn more?
Plan today for tomorrow. It's all spelled out. No numbers. Plan today for tomorrow. Or you could reach me at 914-925-1010.
And you have offices in both Northern and Southern Westchester. Mm-hmm. You're in office. You meet people. You blog. But I encourage our listeners and viewers this morning to go on that website, plantodayfortomorrow.com. Sal's written many, many blogs that touch upon what we've discussed today and so much more. Any upcoming lectures or talks?
September, but I'm not sure when.
Okay, well, that's a little teaser, so you have to join us to learn more. So thank you, Sal, for the great information today. And this is Jen Graziano, thanking you for taking the time to listen as we took the time to talk. Have a great day, everyone. Bye-bye.